and I don't have another one. Sometime I'm going to get another one. They're similar to looking to that murder.
Yes, yes.
Senator Sears, check Bridgewater. They're changing the speed limit,
Oh, good. Oh, no. Higher
Up
or
or
lower?
down, yeah.
making it go
Oh,
higher.
my God.
I've gotten about 5 calls already, people who are upset about it. They want it to stay at 25.
You know, this is the bill to change the Georgia speed trap law.
We're live.
All right, we're live. This is Senate Judiciary. We're taking up S97, Miscellaneous Judicial Procedures Act. There may be an amendment to change laws around speed traps at some point. But for now, we have a number of witnesses to, there's, the first section of the bill has a number of appeals, and I'm going to make it easy on the director of the Racial Disparities in Criminal and Juvenile Justice Systems Advisory Panel by asking him to comment on section 2 before we do a walkthrough of the bill, so he doesn't have to sit here and wait for us to complete work on the bill. Without a change, we would, Eric, if you want to just go right to section 2.
Yeah, certainly.
And then
Eric Fitzpatrick with the
Ethan
opposite.
can-
Sorry, go ahead.
Yeah, no, go ahead. But section 2 just basically repeals the sunset to the RDAP.
Yes, that's exactly right. And you may recall that last year, for a number of these sunsets, including the RDAP one, there was legislation passed to extend the sunset by 1 year. Remember that? What happened was the original idea was to repeal these sunsets completely. And in fact, the Senate and the miscellaneous bill last year, which you passed, you did repeal the sunset completely. So RDAP and the other provisions would become permanent. But because of COVID, there was a decision made that rather than repeal all these sunsets permanently last year, you just extend them for a year and then deal with the subject in more detail this year. So now really this is the same piece that, as I mentioned, it passed the Senate last year and repeals, as you mentioned, Senator Sears, it repeals the sunset so that RDAP would become permanent. That's exactly right.
Hey, Don, if you want to introduce yourself and tell us
Yes,
if you want to keep going.
will do. Good morning, everyone. I'm Eitan Ness Redden Longo, and I am the chair of the Racial Disparities in the Criminal and Juvenile Justice Systems Advisory Panel, and other awkward titles. I'm very much in favor of repealing the sunset and keeping the RDAP as a permanent body. And this is, my comments are also made with consultation of the entire panel. I'm in favor of this for a variety of reasons. We all are. We began, as you know, with that report back in December of 2019, which was essentially an outline of concerns that the panel had concerning very many aspects of both of those systems. There was consensus in that report, likely because we did an overview with a very broad approach. And I think closer examination, which is what we were hoping to do after that, of the various recommendations made in the report, will result in dissension. I would certainly hazard that it is in the dissension that the most probing examination of these systems will come, and that work remains to be done. The body is committed to going back to that report and focusing its attentions upon that proverbial deeper dive. That action has, of course, just begun. It's a huge task, but we all think that it's very much a necessary one. Also, you should recall, if you don't know, that the deeper dive was felt to be necessary by the Joint Judicial Oversight Committee when that December 2019 report was submitted. Members of that committee felt they were pleased by the RDAP's work, but they themselves wanted the deeper dive as well. That report's very much in some ways an outline when I go back and look at it, which I did early this morning. But outlines are very much necessary, as we all know, to the close study. And that is what the RDAP is poised now to do. We were poised to do that last year, but of course, as has already been invoked, the pandemic happened. And along also with Act 148 itself of last year, which necessitated that we concentrate by the 1st of December upon data and produce a report focused upon that topic. That was a great thing, it turns out. It helped lead to H317 of this year. Happily for us, data was part of the original purview of the RDAP. And so this most recent report that we finished in December likely constitutes the deep dive on that part of the panel's original tasking. We feel as a body that we need to go forward. We've just looked closely at data, and there's much more of the 2019 effort that would benefit from the focus that we've just applied to the matter of data. Sunsetting the panel would obviously get in the way, and we don't want that. And we also don't think that it would be a good move for communities of color around the state. That work needs to go on. I think H317 of this year shows that that work is certainly important and needs to continue, and that the RDAP is already constituted and in a good position to continue the work that it's already begun. There is further work to be done that wasn't part of the original report. For instance, there are several issues that have been raised by Chief Don Stevens of the Nulhegan Band of the Kuzuk of the Abnaki Nation, who is a member of the panel. He's raised concerns about the application of the Indian Child Welfare Act here in the state as regards the Abnaki Nation. DCF and the court systems in Vermont have not extended this federal law to Vermont state recognized tribes, whereas other states have done so. And he's concerned, and he's often contacted by people outside of the state who identify as Abnaki for information. In any event, that disparate application of that law, federal law, has had and continues to have detrimental effects on the Abnaki community. He's also concerned about matters pertaining to Abnaki inmates in state prisons who are having problems with legal, spiritual, and cultural practices being denied to them. There are examples of work, these are examples of work that were not considered, as I say, in the 2019 report, that clearly need the focus of the panel now. Again, this is a clear reason not to sunset the body. One issue that a repealing of the sunset of the RDAP raises is the need for a clear and stable interaction between the panel and the legislature. I'm saying this very personally at this point as the chair. I have really no idea what this would look like, but I am more than willing to explore possibilities of this clear and stable link. As chair, I'm often in the dark as to where the panel's work is in the mind and minds of the legislature, and it makes running the body difficult and sometimes even a bit hair-raising. I had no idea that Act 148 had passed last year. The conventional wisdom was when the pandemic hit, everything was going to be about the pandemic. That's not, justice reinvestment's not going anywhere. By accident, I was talking on the phone with Commissioner Sherling, who invited me to a meeting of a legislative body. I don't even remember who it was or what group. He said, "Do you want to come?" I said, "Sure." At that point, Zoom was fun, right? So I went, and Representative Lalonde said, "And what's going on with Act 148?" And I looked like the kid who hadn't done his homework. Act 148, what's that? And he sort of filled me in, and he said, "So what's the RDAP doing?" And I just said nothing. And he kind of looked at me a little alarmed, and I realized that something was very wrong here. Eventually, we got our act together. I got my act together, brought it up to the RDAP, and as you know, the report came out on the 1st of December as it was supposed to do. But obviously, this is no way to run a candy store. So I'm just saying, as chair, I would really like a clear and stable way to get information from the legislature so that those sort of situations don't obtain. The chance involved in that story is really neither safe nor comfortable. It's also, I think, necessary for the legislature to remember that the RDAP is comprised also of community members, as well as governmental actors. And so the information to community members can't really happen through so-called back channels. Again, a clear and stable connection to legislative action and movement would be very helpful, I think, and something to consider. And that kind of connection can't be presumed for people who are outside of legislative channels. Further and importantly, and this is sort of the last section I want to raise, if the legislature is repealing the sunset, it might also want to update the charge of the panel. There's a question, though, that the panel has at the moment concerning the matter of this particular bill. And if the present intent is to get the bill out before crossover, we're not going to go where I'm about to go. We'll wait. If that's the fact, then I've said everything really that I need to say. But we will at some point have something to say about changing the enabling statute of the RDAP if the sunset's repealed. So if this committee is trying to move this bill by crossover, we hope that it will do so, very much so. And then when the bill is in the House, the RDAP can work on a proposal for changing the charge of the panel to align more closely with current legislative priorities.
My goal is to get the bill out today or
Then there it is.
tomorrow.
Then I'll shut up.
But no, but I would like to have you work with legislative council and both judiciary committees to accomplish what you're looking for, so that when we get to, if the House were to add the language you're seeking, that both committees would be aware of it. So you would just communicate with Peggy, and whether it's a joint meeting or whatever, or separate meetings, I would like to be part of that. I'd like this committee to be part of that conversation.
Great. Thank you.
Welcome.
And that's all I have to say.
All right. Well, thank you very much.
Thank you.
Thank you very much.
Any questions for Eitan? Thank you so much. Enjoy the rest of the afternoon. It's
I will.
beautiful out there right now.
It's true. I'm having a few reactions to the injection from the vaccine. So I think I'm going to go have a cup of tea and take it easy.
Yes.
So,
Yep. Take it easy.
have a
All
good
right.
one. Thank you.
Eric, if you want to come back to starting with section 1, we're going to repeal court diversion changes.
Yeah, should I pull up the document real quick?
Yeah.
Yep. Sounds good. But yes, as I'm pulling it up, you're going to see the first few sections are all also repeals, and that they also flow from the same general step that the legislature took last year, which I mentioned, which is that these repeals were, instead of being the sunsets, I should say, rather than being repealed, were all extended by 1 year. That was a decision made during the COVID pandemic, rather than repeal them, extend them by a year, and then come back and address them in more detail this year. So you'll see on page 1 there, we just dealt with section 2 already. That's the RDAP one, again, being extended by a year under existing law, but now the proposal is to repeal the sunset, make it permanent. Section 1, same idea with the court diversion program changes. I should mention again, these passed the Senate last year, repealing the sunset in the miscellaneous bill last year had already passed. But these are the changes that were originally made in 2017 to the diversion program statutes. The two main ones had to do with expanding diversion to include adults with substance abuse or mental health treatment needs. Remember, regardless of the prior criminal history, that was one of the major changes. And the other one was that the prosecutor has to provide the offender with the opportunity to participate in diversion for certain offenses, unless the prosecutor states on the record why doing so would not serve the ends of justice. So those changes have been in effect since 2017, but I think the idea had been to see how they worked, and that's why there was a sunset in. Everyone seems to have agreed that the changes are working well. So section 1 repeals the sunset and they become permanent. RDAP we already talked about. Section 3, same idea with the spousal maintenance and support guidelines. Remember, again, they've been in effect since 2017. Also, although it wasn't in the miscellaneous bill, actually, last year, the repeal of the sunset passed in S99, but that bill wasn't taken up in the House, but it has passed the Senate previously, this repeal of the sunset. And that's what's being done here as well. These are the guidelines that are used for purposes of support decisions that the court makes, spousal maintenance and support decisions. Again, that would become permanent. A slight difference in section 4, this is the Sentencing Commission. This does not repeal the sunset. It just extends it by 2 years. So you'll see line 13. This is the Vermont Sentencing Commission still working on the crime classification project in particular that this committee's looked at as well in previous sessions. So they're still working on that and they still have work to do. So the proposal here is to extend their life, as it were, by 2 more years from 2021 to 2023.
Alice, Senator Nick.
So on, I think it's, what was it, 3 or 2 right there? The issue of spousal maintenance, just something to make you aware of. One of the judges spoke of, you have these guidelines, but the fact is we passed that bill with regard to the de facto parent in our committee, you may remember. And as a result of that, there are no guidelines for those families that are made via a de facto parent or other situations that are not the norm. And they're hoping that some guidelines can be put in. So it's just something that to keep on our radar, that maybe we should have the Bar Association or their family group work on that. So
Okay, maybe they could put
that's all.
that in as a new section. You have language on that. Eric, section 5 repeals the sunset at a 21. Should we do this with 22 instead of 23?
Yeah, of course, whatever you prefer.
I would propose we give it 1 more year.
That's for the
To
Sentencing
finish up
Commission
the
section.
to finish up the assignments we've been given, but I think we're become, I don't know. I think 22 would be enough. They've got certain things in statute right now they need to finish.
Sure, will do. All right, so next we have, sorry, was everybody okay so far?
Yes.
Okay. So now moving on, we got a couple of repeals of a couple of sections in statute. This one, section 5, was requested by the Attorney General's office, and it repeals the statute that provides for civil recovery for retail theft. This is the statute that allows, if someone commits the crime of retail theft, this allows the victim to bring a lawsuit in civil court for money damages. Now, this is an old statute, was passed long before the institution of the restitution system. And now the restitution system covers these sort of situations. It provides a method to make victims whole after a theft is, or any other property crime for that matter, is generally handled through the restitution system. So with that available, the statute is no longer needed. And that's why the proposal is to repeal it. Another statute that's been around a long time that no one really, this is a request by the court. This is a statute that, interesting, none of us ever even sort of knew it was existed until we stumbled upon it while we were republishing a volume in our office. Requires district judges to designate 3 successors to serve if the judge is incapacitated. Very specific. There are no district judges anymore, and in fact, the statute, I think Judge Gerson will have a little more detail on it, but as far as we can tell, it's never been used. Dates from the 1950s. Again, sure, it had a purpose originally, but not any longer. So the proposal is to,
I don't know, maybe we wouldn't need a court administrator or a chief superior judge if the individual judges could assign. Senator Benning.
Thank you. Can we go back one section, Eric, to the civil repeal of the juveniles,
You mean the retail theft one? or-
retail theft, yeah.
Yeah.
I'm curious, the restitution statute enables somebody to be given relief from a limited number of losses, specifically uninsured losses that they can demonstrate. It seems to me if we allow this to go through and take away civil recovery, there may be areas of loss that are not covered by the restitution statute that might be covered in a civil action. And I'm not sure where this came from and whether anybody in deciding that this should be passed as the removal of this area of the law had thought about those two differences. I see Judge Grierson on the screen. The restitution statute is pretty clear about what you're entitled to argue for, but it does not cover things. For instance, I recently had a case where a woman caused a disturbance at a corn maze, and the disturbance was such that there were things damaged, and there were two employees from the corn maze who expended time that they would not have been paid for otherwise. So the question is whether or not in a restitution request, they could have the employees' supposed extra pay taken care of. And I'll skip the what happened at the end of the day, but the question is, the restitution order is limiting it to uninsured losses. And in a civil recovery action, it may be something beyond that, where the owners in that case could make an argument for something else in addition to those restitution limitations. I don't know whether this was ever discussed or there was a conscious decision to simply say we're going to get rid of this because we just don't like it anymore, or what was the rationale behind that?
Yeah, I think you're correct, Senator Benning, that there are some pieces, for example, the fact that restitution requires that the loss be uninsured, and as well there's a penalty available here, as you see in lines 3 and 4, page 2. It's not available in the restitution statute. So there are some elements of this statute that permit recovery that wouldn't be available under restitution. I'm going to defer, though, to, it was requested by the Attorney General's office, and their position was that it was sort of no longer needed because of the restitution statute. So I think perhaps they'd be better able to respond to your point that there are some things that aren't covered by the restitution statute, so as to why this would be the right approach.
Yeah, why don't we continue the walkthrough and then come back to this one?
Okay.
Have our witnesses.
So we were repealing next was the emergency judges, right?
Right. There goes my job.
I like
so-
the idea that you have to break glass to get them.
right.
Man, tough room this morning.
Right. So now we have a couple of sections on probate fees. These clarify what the fees are in certain actions. The first one is a wrongful death action. That's an action that a personal representative brings on behalf of somebody who has wrongfully been killed. The statute requires that when the court appoints a personal representative to bring the action, there's generally a fee, but the statute doesn't specify what the fee is for that appointment. And probate courts have evidently not been in agreement as to what the correct amount of the fee is. So Section 7 resolves that disagreement by specifying that the fee is going to be the same entry fee that's established for small estates, which is $50. So you might want to note that there. It's a cross-reference to what the existing fee is for the establishment of small estates, which you probably remember that term. This committee's dealt with that before. It's a $10,000 limit on what qualifies as a small estate. And that fee is $50, which would then become the fee as well for appointing the representative. Another fee section here. This has to do with registering a foreign guardianship with the probate court. Evidently, this comports with current practice. Again, the statute wasn't clear. There is a long list of what the fees are in probate court, but for this one wasn't covered, the foreign guardianship registration. And so my understanding is that had been interpreted as $90, but this clarifies it so that there's consistency. You'll also see on line 7 there, it's existing law, but that's the cross-reference that we just saw in the previous statute. See, the small estates less than $10,000, that's a $50 fee. And that's the one that you just referred, the proposal was to refer to it here for personal representative cases. So that's how you rope in the $50. Now we have a couple of Judicial Bureau pieces, and these again, some cleanup on the Judicial Bureau statute. This is the first one. You see line 19 and 20, that's just an incorrect cross-reference. That's a reference to the hazing cases. Those cases are in the jurisdiction of the Judicial Bureau, but they were relocated to a different chapter of Title 16, and we didn't get make the correction to the cross-reference when that happened. So that's done here. Subdivision 19, this is proposal here is to strike this entirely because the process that's referred to here, which is obtaining the Vermont Seal of Quality for agricultural products, has been repealed, no longer exists. So there's no reason these cases aren't going to happen anymore because that process has been entirely repealed. And therefore this statement about Judicial Bureau jurisdiction over those cases also is no longer needed. So that's repealed also. The last piece here, you see there's a lot of language, but it's in a nutshell, and I'll explain to you quickly here. This probably looks familiar to you. This is basically reconciling an error that happened because both Act 164, which is the Cannabis Tax and Regulate Bill that you passed last year, and the 2019 T-Bill, the Transportation Bill, both made amendments to the same statutes regarding blood draws, roadside blood draws, for the purpose of determining the presence of alcohol or drugs. Now, because it took a very long time, as we all know, for Act 164 to get through the legislative process, the two amendments ended up being inconsistent, and the one that was in the T-Bill didn't make it into the final Act of 164. This corrects that issue. So basically, I understand from talking to Michelle, these were issues that Senate Judiciary in particular was dealing with and was important to. And those are the issues that you essentially are specifying that a blood draw, for purposes of determining whether a person has alcohol or another drug in their blood, has to happen at a medical facility or police or fire department or other location. Can't be done by a law enforcement officer roadside or by anyone else roadside. So that was all that does is the way the two acts, because they passed inconsistently. Right now, these provisions that the committee worked on are going to be repealed when Act 164 goes into effect on January 1st of 2022. You obviously don't want those to be repealed. That's an oversight. So what this does is it basically reenacts the same provisions that you passed, but in a way that makes sure that they're not going to be repealed when Act 164 goes into effect in January. The language is identical.
Dates. Yeah, effective dates.
That's right.
Okay, thank you for that walkthrough, Eric.
Yeah,
Are there
I think
any
that's the last.
questions about Eric's walkthrough? The only thing I would ask that you let the finance committee or whoever's the counsel for finance know about the fees in Section 8, so they don't get taken by surprise.
Oh, yes, good point. Thank you.
I don't want to overstep my bounds dealing with fees. I don't. All right. My internet connection's unstable, whatever that means.
Shall I pull out the document?
No, it's just my internet connection's unstable. Now I need to. Judge Grierson.
Good morning again,
Good morning again.
and thank you for inviting me to testify in S97. the miscellaneous judiciary bill. And obviously, as Eric has indicated, not all the provisions of the bill are requested by the judiciary. Trying to find my copy of the bill. The first section that deals with us was, if I can find it, involve the emergency judges. And I was quite frankly not familiar with that process, but I appreciated your comments, Senator Sears, that maybe that would be a way of, if I left that intact, that it could relieve some of the burden and responsibilities on the chief superior judge. But I will say that Eric wrote to me. I had never, I guess for the record, Brian Grierson, chief superior judge. I had not heard of this provision. I do not know the history. It's never been used as far as I'm aware of. I hope it hasn't been used. Put it that way. I'm not aware that it has. So we would respectfully ask the committee to repeal that section. The next two sections.
So you don't, I wonder if anybody's ever filed in the office of the governor and the county clerk.
I don't know. I get requests pursuant to the statute periodically to appoint attorneys as a judge for the day so that they can do a marriage ceremony, but that's the extent of the emergencies and limited.
It's interesting language.
It is very. If you go back, if it's 1950s, of course, that's when there really was a distinction between district court and superior court. The district court judges remained in their respective seats. They had jurisdiction over all criminal matters except homicides, which were in the superior court. So it was a somewhat limited jurisdiction court. But nevertheless, I think we can dispense with it if the committee is so inclined. The next two sections, as Eric pointed out, involve the probate court. I can tell you on the first section where that comes about, it is for clarification, because when someone has a personal injury action that they're bringing and they have to appoint for a death case and they have to appoint an administrator, apparently some of the probate judges were assessing this fee, the somewhat standard fee for this type of proceeding, but others were assessing a fee based on the size of the settlement, similar to what they do with a trust. And so this was presented to the probate oversight committee, and there was I don't remember off the top of my head whether it was unanimous or essentially a consensus from that committee that went out to the probate judges, and I have not heard any objection to now making this a standard fee for these types of proceedings. The second one is similar, that there is some confusion. I don't have a lot of details on that second provision. This is the foreign guardianships, other than it was requested for clarification of the appropriate fee, and it's a registration of a guardianship order, that it comes from another state, and that fee, I believe, is similar to what we require for other out-of-state domestic orders of that kind. And finally, the provision relating to Judicial Bureau, I really can't add anything to Eric's comments other than that these are provisions that just need to correct mistakes in the current statute. There's nothing, not adding any new provisions. It's again for clarification. And so that's really all I have, unless the committee has any questions or other areas they wanted to ask.
Any questions for Judge Gerson? Hearing none. Okay.
Thank you.
James Pepper and David Schur. I don't know which one of you wants to speak first. Go ahead.
I'm happy to defer to David if he's got a.
Yeah, I think David's got the diversion and a couple of other issues, right?
Thank you, Senator. For the record, David Chair with the Attorney General's office. I'm going to speed through a couple things because I don't think they're particularly complex or controversial. and then address Senator Benning's question about the retail theft issue. Looks like, oh, there's Senator Benning, sorry. The tiles moved on me. We certainly support the repeal of the sunset on the racial disparities panel. It's working well. I think it's increasingly becoming a part of the policymaking process in a positive way in Vermont, and appreciate the work that's being done there. We support the repeal of the sunset on the diversion changes that were made in 2017. I think they've been very successful. Diversion has, other than this last year where all the data is strange because of the pandemic, it's diversion use has more than doubled. The Tamarack program has grown. It was invented in 2017 and is being used quite significantly in the years since. So we support that. Don't think there's any issue there. I did want to address the retail theft question. So this is arising from our diversion programs because we do have people who commit retail thefts, and those often go to diversion, at which point those folks are given a restitution judgment order, or they have restitution as part of their diversion program. It's a requirement that they complete their restitution in order to complete diversion. And the way that we've structured it is that even if somebody were to otherwise complete diversion, they would still be on the hook because of an MOU we have with the restitution, with the Center for Crime Victim Services, that makes sure that they complete that restitution requirement. However, we see people who are going through all of this, are doing what they're supposed to do, and they get sent these requests for, basically civil demands from lawsuit mill type law firms from Florida, places like that. Not Vermont companies, not Vermont law firms, not really, it's all the big chains that are doing this. They seem to have ongoing contracts with some of these mill type law firms that are just filing these without any real attention to the facts of the case. And so folks who are under our laws doing what they need to do to make things right are getting hammered with these lawsuits. It's really important, and they're, these companies are recovering anyway in the cases that we see. It's really important to note a couple things about this statute. It caps the recovery at $300. So it's not actually providing much relief for any serious loss. And it also is really limited just to theft of merchandise. So things like the corn maze issue, loss of wages, things like that cannot be recovered under this statute anyway. It's very limited. It's not really being used as far as we can tell, other than these lawsuit mill type law firms from out of state just peppering people with demand letters. And so we don't think that people who have been harmed are being made whole through this. The $300 cap means that it's not being used for serious cases anyway. And the restitution and diversion system we think is working well. And it's not been helpful to see people in diversion get hit with these demand letters that are kind of worthless anyway, given the fact that the people are being made whole. So that's why we've asked for it. We do think it's a bit of a relic to deal with a very specific retail theft problem retail theft of merchandise problem that is being better handled through our restitution and often our diversion system. And that's why we're asking for that to be struck.
I don't want to do it here, but at some point I'd like to have a conversation about these lawsuit mills. They are a problem. I have one constituent who has been hammered by them because on his website he didn't have it technically correct for blind people to be able to use it, or visually impaired people, I should say. And he got notices from Florida that he was being sued. Something that we should probably look at. Consumer protection.
Yeah, we're happy to have that larger conversation as part of the consumer protection world as well.
Yeah. But anything else? Any other questions on any of the parts that have David? Okay, great.
Thank you.
Pepper?
Hey, for the record, James Pepper, Department of State's Attorneys and Sheriffs. So the miscellaneous bill, the state's attorneys did not specifically ask for any of these provisions. However, we are supportive of the entire bill, but the ones that are related to the prosecutors, Section 1, the repeal of the sunset for presumptive diversion for expungement eligible misdemeanors. The state attorneys are supportive. As David Chair mentioned, we've seen a huge increase in the utilization of diversion in Tamarack. That's a direct result of this presumption. And so we support the repeal of the sunset. Section 2, repealing the sunset repealing the sunset for the racial disparities panel, support that, of course. The work that we've been doing, I've been a member since the beginning, and I think there's a lot of really important work left to be done there. The Sentencing Commission extending the sunset by a year, I think that will provide sufficient time to complete the kind of statutory requirements that are left, and some of the initiatives that the Sentencing Commission has established in its most recent report, as well as doing some of the work that is going to be required through the S7 expungement bill. So I think that's all. I would just want to note, our juvenile justice stakeholder group, which has overseen the implementation of Act 201, the raise the age of juvenile jurisdiction, has been meeting continuously for the past 3-4 years, every other week. We've identified a few technical amendments. We really do believe they are technical, related to the implementation of raise the age. It took us a little while to kind of get the language together in a workable form. So I really do believe they are technical. They're supported by all members of the stakeholder group, including DMV and DCF, the Defender General, the state's attorneys, the Attorney General. I haven't had a chance to get them over to Eric, but I just didn't want to miss the opportunity to let you know that we would like to try to put those in on the House side if this bill does advance.
I guess I would say the same thing to you as offered on the racial and disparities. If there are changes you'd like to see made, we would contact Eric and this committee, so we're aware of those changes. I don't want to get into, oh God, what did they add?
Yeah, that makes sense, and I'm sorry that we didn't have enough time.
Well, the bill was late getting introduced because we were still putting things together. Senator Benning.
Senator Sears, unfortunately, I've got to leave in 60 seconds for the Joint Legislative Management Committee.
Okay, well, we're not going to vote on this. I'm going to try to find some time to put it in, so you may leave. We'll vote on it tomorrow morning at sometime. Peggy and I'll work on it. It's scheduled for tomorrow morning to vote on it.
Thank you.
Giving Eric some time to redraft.
I didn't think there is any redraft of this other than.
Well, yeah,
changing
we're
the date.
changing one date. Yeah.